The order. Would welcome everybody here. Thanks for coming, and we'll have roll call.
Chairman Rick Johnson.
Here.
Donald Bailey.
Here.
Vivian Picard. Here. Nicole Cover. Here. David LaMontagne.
Here.
Chairman Johnson, you have a quorum.
Thank you. Public comment will be limited to 2 minutes. I also want to please remind everyone that is wishing to speak not to address anything that would be before the board today or the next meeting or in the future. Would appreciate that. Approval of the agenda. As all members had a chance to look at.
Motion to approve.
Their support. Support. It's been moved and supported for approval of the agenda. All in favor, say aye.
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 Opposed, same. Agenda has been approved. We have minutes from May the 3rd. Everyone had a moment to look at those.
Motion to approve.
Their support.
Support.
It's been moved and supported to approve the minutes of May 3rd, 2018. All in favor, say aye.
Aye.
Opposed, same. Motion carries. Old business. We have no old business. That gets us to new business and pre-qualification applications. First on the list is Center Creek LLC. Have members had the opportunity to review that? Any desire from anyone to chat about it or have a motion? Or what's your desire? Well, if no one wants to make a motion, the chairman will. I would move that we approve Center Creek LLC as an applicant for pre-qualification. Is there support?
Support.
Been moved and supported. Discussion on number 1. Go ahead. Sorry.
Mr. Chairman, on Center Creek, I have questions regarding Midwest Wellness Center LLC. It was disclosed in the application that it was not a marijuana facility as associated with Center Creek LLC, but in fact, through subsequent investigation, it turns out that it is, and that's a problem for me. Going towards transparency in the application on this.
If I could provide information on that, that was an alteration. I don't believe in the application process that on the disclosures that applicants are required business that they're in. The statement by the analyst is put in your report.
So in the director's report, when it says that it's not a marijuana entity.
That was an error on the analyst part. That information.
I can hear you.
That was an error in the report. That is not something that was disclosed or failed to be disclosed by the applicant. That was an error on our part. And that's why I corrected it this morning, because we had received an email after we asked about what that consulting firm was. And they did identify that it is related to the marijuana industry. in that he consults in growing, and as you see in the report. But that was an error on our part, not on the part of the applicant.
Okay, thank you.
Any other questions? Call the roll.
Chairman Johnson,
Yes.
Donald Bailey,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Thank you. Number 2, compassionate care by design. Comments, thoughts, suggestions, motions?
Madam Chair, I'm sorry, Madam Chair.
That's all right.
Mr. Chair, I move that
Good call,
pre-qualification status for pending application for for compassionate care by design.
Okay. Is there support?
Support.
Comments? Suggestions? Motions? No, then the chairman will move to approve compassionate care by design.
We've got a motion already on the table.
We do? Oh, I'm sorry. That's right, you did. You got an alpha.
That's okay.
No other discussion? All right, then call the roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Thank you. Number 3, professional growth ventures. Comments on this one? Thoughts?
And Mr. Chair, I could point out as well that these, the applicants on this are the same applicants that are on the Source Direct. So I don't know if you want to consider those one after the other, or if you want to do them in order, but I just thought I would point that out for you.
Well, we've approved the agenda with the current lineup, but probably,
Okay.
if you want to vary from that, but,
All right.
so this applicant then is applying for 2 pre-qualifications?
Right. They have 2 separate LLCs that are on the agenda for pre-qualification. I apologize. We'll just do them in order. That's
Oh, that's okay.
my mistake.
Mr. Chairman, are we going to have discussion before we make a motion?
I think you have to have a motion.
Yeah, technically,
Have
we
to
should
have a
have a
motion.
motion.
Preferably, we should have a motion first and then discuss.
Based on what I've seen in this application, I would make a motion to deny this application.
Is there support?
Support.
You'll need to cite a statutory reason for the denial.
Well, let's have our discussion first. And there's multiple things to do that on. Yeah, I think the big one would be the non-disclosure, but you want to put it down on non-disclosure, Kelly, that's fine. But let's open up for discussion on number 3.
Mr. Chairman, one of the 2 applicants on professional growth ventures, Mr. Sula Jamni, had 2 undisclosed arrests that were discovered on the application. There are also several other issues that maybe we do or don't need to get into that trouble me in this application between both applicants.
Any other comment? Oh, go ahead and call the vote.
We'll want a
Oh.
statutory reason for the denial. We can cite to the statute. And you've got in your sample
It's
motions.
non-disclosure, whichever one that is.
What is it?
At 4022C, the applicant knowingly submitted an application for a license under this act that contains false information.
Yes, Mr. Chairman, I would move to deny Professional Growth Ventures LLC application because the applicant is not qualified to receive a license under the Medical Marijuana Facility Licensing Act, Section 402(2)C, the MMFLA sections of emergency rules.
Okay, please call the roll.
And I'm sorry, we had a second by Ms. Picard. Do you agree with are we
Yes.
treating this as a friendly amendment to the
Yes.
motion? Thank you.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne. Chairman Johnson, you have 5 yeses, motion passes.
Okay, thank you. Number 4. Not really sure what it's ETHCX1 LLC. Comments on this one? Your motion.
Chair, I move that ETHCX1 has pre-qualification status for pending application.
Is there support?
Support.
Is there discussion?
Mr. Chairman, this application began with 2 members in the course of the LARA and the state police investigation of this. One of the members, who was a 70% owner, Mr. Ali, as a 70% owner, a Michigan resident. The other owner is from the state of New York. Mr. Ali was arrested on a charge for 5 to 20 kilograms of marijuana. And the day after that, he was dropped from the application, and the New York resident, Mr. Kupferman, proceeded without him. Mr. Kupferman doesn't live in the state. He's going to be relying on Mr. Ali, in my opinion, to run this place, although it's simply not going to be on paper that he's a part of the organization. I don't think that, at least for me, that I can vote for this application for that reason.
Any other comments? Thoughts? Call the roll on ETHCX1.
Chairman Johnson,
No.
Donald Bailey,
No.
Vivian Picard,
No.
Nicole Cover,
No.
David LaMontagne.
The motion was to pre-qualify. I want to make sure everybody's clear.
Yep. Mhm.
And I'm sorry, I don't believe we heard from Mr. LaMontagne.
No.
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 Thank you.
Chairman Johnson, you have 0 yeses and 5 noes, motion fails.
Can I ask a question?
Yeah.
Sure.
So when an application gets submitted and the background checks are done, which we know this Mr. Ali was originally on it, correct? Because we have all this of what happened, and which I agree with what we discussed. And then they're allowed to go in and remove the name? Is it when it's still in pending status, or?
That's a good question for Chris.
Because it seems like we haven't denied them, but all of a sudden, like, they're just allowed to come in. Well, like, if I'm a pharmacist and I do my application, I can't like change it as it's in the middle of something.
Right. Well, there's nothing in the rules that would preclude them altering or amending their
Okay.
application.
Okay.
In this case, they did the legal forms necessary to remove. There were actually three persons
Right.
as part of the LLC.
That's why I'm asking, because it's like they're all gone now.
Right. 2 of them withdrew from the application. They actually did the legal paperwork to remove themselves from the LLC.
Okay.
And because they did that, we didn't provide all of the background information, but we did provide information on how the applications began.
Okay.
So that you would know the progression of how it arrived to us and how it arrives to you
Which
now.
I appreciate. Yep. Okay.
So that
I just didn't know if it was considered pending when they applied, but it sounds like they can up until we meet.
Yes,
Okay.
yes. But we document that,
Okay.
all the changes.
Thank you.
Number 5, A and K.
Whoops, we got it.
Hey, Mr. Chairman, we'll
Gotta
want a
deal
new
with that one.
motion on
Oh, okay.
application number 4, since the previous one failed.
Oh, that's right.
Already been voted down.
The first motion was to pre-qualify. Do we have a new motion to deny or further discuss?
Mr. Chairman,
Affirmative.
I move for denial of ETHCX1 LLC.
Same reason as last one.
Correct.
There's support.
support, but I think it also,
Add 402,
It's
3A.
yeah, that's what I was just going to say.
Integrity, moral character, reputation, personal and business, probability, finance. I think that.
So it's two.
402, 3A.
So there are two codes.
Okay, is that okay with?
Do we have a second?
I second the motion.
Okay. Then you'll need to vote yes to deny. Okay, all in favor, or excuse me, clerk call the roll?
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Clover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses, motion passes.
Thank you. Number 5, A&K Enterprises. Any wishes here? Then,
I move that A&K has pre-qualification status for a pending application.
is there support? I'll support it. Is there discussion?
Mr. Chairman, I did note that there was an undisclosed arrest for Jeffrey Angst, one of the 2 applicants for A&K, from a marijuana arrest. Granted, it was from 1981. I don't think anyone's too concerned about the nature of that, except for the non-disclosure, which happens now. That didn't happen in 1981. That's my only concern on that one that I could identify.
Yeah, I just had a question if there was some sort of statute of limitations. It just seemed like a really, don't know if there is a statute of limitations.
The only thing I think
I'm
we
only
need.
42, that's a long time ago.
I noted that, but still, I didn't.
Yeah, I didn't
it was
know.
So
I
old.
I
The
just
old
didn't know,
marijuana
yeah.
charges, they were so old, I didn't see it as a major problem at this point.
The only thing I'm concerned about is being consistent.
No, I agree. Yep.
I'm not concerned about the 1981 arrest for possession of marijuana.
On the disclosure form, there's no limitation in time. The question is, have you ever?
Okay.
And it lists the arrest charge, dismissed, all of the possibilities.
Okay. Prior, that was my only notice.
Any other discussion?
A motion to pre-qualify on the table?
Yep, please call the roll.
Can I change the motion to not have to vote twice? Or do we need to go through this?
Withdraw.
Yeah, you would,
Withdraw the motion.
Okay, I can withdraw.
oh, you did. That's right. Yep, okay, and so it's okay with you?
Yes.
Or me, whichever one it was. Okay, the motion has been withdrawn. Is there a new motion?
I move to deny A&K Enterprise application because the applicant is not qualified to receive a license under the Medical Marijuana Facilities Licensing Act under section 4022C.
Support for that?
Support.
Any other discussion? Again, a yes vote is to deny. Call the roll, please.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Clover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses, motion passes.
Thank you. It's denied. A question for the staff at this point. When how do you handle an old disclosure? I mean, I don't know this individual or individuals, how old or, 81. I don't remember what I was doing in 81, quite frankly, other than farming, but.
How we handle it is they fill out the disclosure. If something shows up on a rap sheet or through MSP investigation that wasn't disclosed, either we through email or MSP, sometimes through email or phone or face-to-face, will make contact with the applicant and ask them about it, and they provide an explanation. Those explanations are provided in your documentation, and so then it's up to the board to determine whether or not, because 402(2)(c) says the applicant knowingly submitted. So there is an element of intent there. So the board can look at all of that, in my estimation, under the rules, to determine whether or not they believe they knowingly submitted an application that contains false information. That's the way I interpret that rule. But I'm, of course,
Basically, you're saying no wiggle room. Correct on that?
if the board finds that they knowingly submitted a false application or false information,
Knowingly is the key
and
word.
it's up to the board to determine factually whether they knowingly submitted an application for a license under this act that contains false information. That's my interpretation, and of course the Attorney General can speak up and with a different perspective if they believe so.
I don't think we can help this individual, this one today, but I'm looking forward into the next one.
And bear in mind, when an individual is denied pre-qualification, the applicant can request a hearing at which they can provide additional information. Then the hearing record will come to the board for further consideration and a determination whether, based on the additional information from the hearing, you wish to uphold your prior decision to deny pre-qualification or not, based on additional explanation provided at that
That
point.
would be an ALJ who will then, similar to other boards, give a recommendation based on what.
That's right. There would be an administrative hearing in front of an administrative law judge who would write what's called a proposal for decision. Both parties would then have an opportunity to write what are known as exceptions or points of disagreement with the ALJ. All that information then would come to the board to decide whether or not you wish to still deny the applicant, or whether you determine that the submission of or the lack of information was knowing or not.
And I think too that it should be noted that it wasn't a traffic violation. I mean, you're applying for a medical marijuana license and it was a marijuana charge. I mean, I would think that would be the first thing on my mind that I would want to on there. So, okay.
Okay, thanks to both of you. Number 6. Pardon me? Number 6, Free Reign LLC. Thoughts on this one to the board members?
Mr. Chairman, I make a motion to approve. I'm sorry. Yes, Free Reign. Free Reign LLC for a license, pre-qualification for a license.
Support.
Been moved and supported. Any discussion? Hearing none?
The motion is to pre-qualify Free Reign.
That's correct. Go ahead and call the roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 7, Herbal Health.
Mr. Chair, move to deny applications because the applicant is not qualified to receive a license under medical marijuana licensing act, and I'm citing code 40238.
Is there support? Oh, excuse me. Is there support for that?
Support.
Board discussion? None? Then go ahead and call the roll. Motion is to deny.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses, motion passes.
Thank you. Number 8, Straw Hat LLC. Any members wish to?
Do we need a motion on this one?
Herbie?
This matter was previously tabled.
Oh, it was.
Just
we
gonna
did?
ask, do we have to
Okay.
untable it? Okay.
Good to know. We need a motion to bring it off the table.
Yeah, motion to untable agenda item number 8, Straw Hat LLC.
Is there support for that?
Support.
Moved and supported to remove Straw Hat from being tabled and come before the board. Call the roll, please.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Motion passes.
Is there a thoughts, discussion, motion?
Mr. Chairman, I would make a motion to deny Straw Hat based on section 4023A.
Is there support for that?
I'll support for the purpose of discussion.
Okay, it's been moved and supported to deny applicant line number 8, Straw Hat. Discussion.
Mr. Chairman, this is an application that we tabled, and there was a discussion on several things to deal with one of the applicants, Mr. Schulteis. This was started off with a marijuana conviction that I made note of that was in the background, of course. It was a 4,000 plant grow. It was a conviction in the state of Minnesota. It was a federal conviction. 3.5 years, I believe, in federal prison for that. And when he got out, it looks, from what I can tell from all the accounts and from what we've been able to determine through the state police investigation, through the Lara background investigation, that he's went right back into the marijuana business. And 4,000 plant marijuana grow is significant. That's not 50 plants in your basement. This is a large scale operation, and you don't get there overnight. I think his life's work has been in the illegal marijuana market, and with so much money to be made, I don't think that has stopped, and I don't think it will stop outside of the regulation that we're going to have. I think there's going to be a lot of opportunity. We all know that for someone that doesn't have the integrity, that doesn't have the honesty to do what we're asking to do, because we can't be everywhere. Lara cannot be everywhere. That this is ripe for abuses within the licensed facility under the MFLA.
Did he disclose this?
ERS? Yes.
Was disclosed?
Yes, it was disclosed. And I believe if you recall from the MSP follow-up investigation that was done, they met with him and they did see the plants that he was currently growing under the 2008 Act. And the plants that were there were within the scope of that 2008 Act.
Right. He had 72 plants, and that was on 3 weeks' notice. So if there had been anything over, certainly with 3 weeks' notice, he would have gotten that into line in that 3 weeks before the state police were finally given authority to go out there from Lara. The other issue with the 2008 law, and this is one of the things that has been a problem since day one, is these caregivers. It was designed, it was voted on, it was written for the compassionate care to provide marijuana. You could not make any money. And if you can't make any money, and he has said in his state police follow-up interviews that he has made money, and he is making money. He has deposits, and his deposits into his account don't line up with the amount of money that he's claiming from his caregiver business, which he can't claim income because that's not allowed under the 2008 law. Anytime there's a chance to make a twist in what's allowed, many people are doing that and have done that. And I believe that's one, and I think that's going to continue on under our licensing authority.
Any other comments?
It's important to keep in mind to make sure that the decisions are based on the record in front of you and the information that you have in the investigation and all the materials that are provided to you through the MSP investigation and everything else that comes to light through the Bureau's investigation.
If I could provide a little clarification on the 2008 Act, it does allow for recoupment of costs and for money to compensate for their time. There's nothing, I'm not aware of any case law or anything that actually interprets that and tells us, what does that mean? Does that mean minimum wage per hour? Does that mean, I mean, it doesn't, we don't know that. So technically they can profit to the extent that they're charging for their time. So I just wanted to make
Actually,
sure
that's an interpretation. That's not in the law.
Right.
It says you can be compensated for cost. And so the interpretation that your time is a part of that, that's an interpretation that's not in the law. And when that was presented in 2008, that was not one of the arguments that was made, as they were selling that in 2008 as a ballot proposal.
I would ask the Attorney General's office maybe in anticipation of the next meeting to perhaps, because I think that's going to come up multiple times,
Yes.
to provide some legal expertise on the 2008 and what it does allow a caregiver to do. Because I thought that was in the statute, and I may be mistaken, but I believe it's in the statute.
I believe it was
certainly send us a request to look into any legal questions.
And I believe it was in People v. Redden where the Supreme Court also made the note that, which was one of the first cases that came along under the MFLA, that you couldn't make any money. You couldn't profit from this. It was simply for the compassionate care to these patients, and you could recoup your costs.
Isn't this the one also that was tabled because the spouses needed background check?
Yes, it was. There were two spouses that did not originally have fingerprint checks. They did. And the information was in the report that there were no issues on those.
So a question here, because I think we're going to run into this more and more possibly. First off, I don't understand why this wasn't cleared up by what's it called, Straw Hat LLC.
By what?
Similar to what the two we were talking about that removed their part of their membership.
What wasn't cleared up? I'm sorry, I don't follow.
Nothing. I'm just saying, it's, we've got a pretty viable application is what I'm saying, other than this one issue. And going forward, if this is to get approved for background, I'd have a hard time supporting the license at the end of the day with an issue this large.
I'm sorry, I'm still not following on which issue we're talking about that's this large. Are we talking about the caregiver, or what are we talking about?
Talking about the arrest that was made.
Oh, he disclosed that. Mm-hmm. It does not make him ineligible under 402(2)A. It is something that can be considered under 402(3).
Right, which is what was done.
Prior criminal, it can certainly be considered, but it's discretionary by the board.
Right. All right, said my piece.
The other question that I didn't know on this particular one is when we get that report and it says an undisclosed associate, and maybe, like, so it had an undisclosed associate's name and then it had all the disclosed people that were associated, and all of that list of people had a background check, but this one individual was not a part of the application. It was the Riemann report.
Oh,
So do we need to be, I just didn't know if that was a concern, like we should request that person or?
the Raymond report draws a lot of information from multiple public databases.
Okay.
And there's maybe people listed as associates, or you may be listed as associated to an address or some other concern that you really may not have any association with. It could be inaccurate.
Okay.
So we follow up to find out what is accurate and what's not, and
Okay.
we follow those. But those reports are
Sure.
just from
No, I
public
get it.
databases.
I just didn't know if it meant they were on an account together
No,
or
no.
something that we need to make sure. Okay.
No, it just means in some association, it could be they lived at the same address 10 years apart or whatever. There's lots of ways it pops up.
Okay.
Any other discussion? The roll, the motion is to deny.
Chairman Johnson,
No.
Donald Bailey,
Yes.
Vivian Picard,
No.
Okay.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 3 yeses and 2 noes. Motion passes.
Okay. Let's see. Number 9, Inkster Pine Park.
Mr. Chair, I move that Inkster Pine Park has pre-qualification status for a pending application.
For support?
I'll
Support.
support. Sorry.
Is there discussion? No discussion? The motion is to approve Inkster Pine Park. Call the roll,
For
please.
pre-qualification.
For pre-qual, yeah, I'll just take that as being there.
Chairman Johnson,
Yes.
Donald Bailey,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Okay, thank you. Number 10, I'm not real sure how to pronounce it. Is it Pirelli Investments? LC is number 10. Suggestion, comments from the board?
Chair, I move that Pirelli Investments has pre-qualification status for a pending application.
Is there support?
Support.
Discussion?
Mr. Chairman, and when I reviewed this in going over some of the financials, there was a lot of very large unexplained deposits. There was a written explanation that was sought in follow-up of that. And the responses initially were pretty much across the board fairly inadequate. One of them describing a $2,800 deposit. When the LARA analyst asked for clarification, they wanted to know the source of that and what it was, what it was for. And the response was that it was either cash or check. And they did a follow-up yet again after that. And many of the responses were the same. I think there's, for me, there's issues with the money that doesn't really sit well, and that concerns me. Two bites at the apple to make an explanation on a deficiency, and it still didn't get to the heart of what these deposits were.
Any other comments? Comments? Then go ahead and call a roll on pre-application filing for Prinelli Investments.
To pre-qualify.
Pre-qualify. Say that wrong, did I? Sorry.
Chairman Johnson,
No.
Donald Bailey,
No.
Vivian Picard,
Yes.
Nicole Cover,
No.
David LaMontagne.
Yes.
Chairman Johnson, you have 2 yeses, 3 noes. Motion fails.
Do we have a new motion?
Mr. Chairman, I make a motion to deny.
Is there support for that?
Wait, I got to finish the
Oh, you didn't?
motion.
Okay, I'm sorry.
I'm slow. Pirelli Investments. I move to deny Pirelli Investments LLC application because the application is not qualified to receive a license under the Medical Marijuana Facility Licensing Act, Section 4023A. I don't think there's been an adequate explanation, and I think there's a reason for that it can't be adequately explained.
Support?
Support.
Moved and supported to deny. Any other discussion?
Mr. Chairman, I just got I'm not disagreeing with talking about here. Not an integrity issue, not a character issue. It's just a discussion. What's the
I think it goes to integrity. I think there's a reason why we can't get a clear explanation, and I think that goes to the integrity and the honesty of the application.
And the only thing I'll add in the, sorry, go ahead, Dee.
So we're basing it on an assumption as opposed to a definitive reason, my opinion.
Well, in part, you're correct, and I think we have to be really careful and on all of these licenses, which I think we have for the most part. And
I agree with that, Don, but I also agree that we should not be basing on assumptions as opposed to definitive information.
And the only thing I would add is, because I bought a house 2 years ago, and I mean, I couldn't be 10 cents different. Like they said, then you've got to go to the bank and you've got to get a statement. Like there's a lot of like, well, I opened the account, I added. If that could be cleared up, then this would be a different conversation for me. But if I can't buy a house because I have to show where I got the $200 as a birthday gift from my mom, I should know that that was a $200 check as a birthday gift from my mom. Like there's still a lot of unanswered, it just the timeline didn't make sense to me. Otherwise, I was fine with the whole application. But I think if we have all these governing bodies that everybody has to disclose where they're getting everything, it's a slippery slope if we allow somebody to not tell us where everything came from, because that's what we've asked for. That was I just didn't like the timeline. Like I added him, I deleted him, I brought my son onto the account. Like there was a lot of, it was even, it was handwritten. It was, I don't know, it just didn't come across like as a true timeline. If he could just give us that, it would be a different, but to say that there's no statements, then, the bank could at least verify something.
And to that end, there was two, I believe Laura gave him 2 opportunities to make things make sense.
Yeah, like a timeline or
And
something.
they still did not come around to
Then
that
my
point.
recommendation is if we cannot get definitive answers, that those applicants not move forward until we get the definitive answers. So, because right now we're we're basing on kind of an assumption based on the fact that if Laura says, we're giving you one more opportunity to give us a definitive answer on where this money came from.
But I can tell, I agree with what you're saying. If we hadn't given them that opportunity, but what I read is we did give them the opportunity to explain that. And what I think the department does then is just assume that what we have is true. Like if they haven't taken the time to tell us that it's not true.
And I think it was 2 opportunities. And at some point, this process has been long and laborious for all of us. Most importantly for all the analysts at Lara. And so now with 2 opportunities to clear the record. They still didn't do it. I think my position would be we need to move on.
Then I too would suggest that Laura, in these, that they say to these applicants, we're giving you one final opportunity to clarify it.
I believe in the email response that in that handwritten list, there were 3 out of there that they were not specific. All of the others were transfers from another account, and they identified the account.
And they did identify.
There were 3 that were not specific. When we asked for information the second time, one was documented from the son's earnings for school, which was the one they answered could be it's either a check or cash. And then the other 2 they identified as being cash. They operate a yogurt store, and they gave a description of how they handle cash transactions. I don't want to say anything about that in a public forum. It's in your documentation. And so the way we took it is it's up to the board to determine whether they believe that is a plausible explanation or it's not a plausible explanation.
And again, we have a motion to deny on the table. Remember that if you deny the application, the applicant can request a hearing at which they can provide additional information. They would have the burden to demonstrate that their suitability for the license, and then it would come back to the board with any additional information through the hearing process for further consideration.
So it's not the end of the road, even at that point.
Right. If you deny, the applicant can request a hearing if they choose to do so, and then it will come back to the board to decide whether you affirm or modify or reverse your decision to deny the license at that point.
Yeah, I think we've kicked it around enough here. Let's call a roll on denial.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
No.
Nicole Cover,
No.
David LaMontagne.
Yes.
Chairman Johnson, you have 3 yeses and 2 nos. Motion passes.
Okay, thank you. Number 11, the applicant is CLDD LLC. Any direction from anyone? Get this started.
Mr. Chairman, I make a motion to pre-qualify CLDD LLC.
Okay, it's been moved and supported to approve CLDD for a pre-qualification. Any discussion? Hearing none. David?
No, sir.
Go ahead and call roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Thank you. Number 12, RL Solutions. Wish is here.
Mr. Chair, I move that RL Solutions has pre-qualification status for pending application.
Was this chaired previously? I'm sorry, was it tabled previously, I think?
Yeah, is this the other one we tabled?
Oh, we only had one that was tabled.
Yeah, I don't think so.
Okay. Okay, is there support for the,
Second.
moved and supported, discussion on RL Solutions?
Mr. Chairman, I'm looking for it in my notes. There were some discrepancies in the tax returns and in how some of the equipment was handled. Again, we know from talking to some of the CPAs in the business that one of the issues that these marijuana facilities have under 280E is they're not able to write off in depreciation any of their marijuana equipment. Which I'm not in business, but I understand that could be quite an issue if you can't write off depreciation for your equipment. And the workaround for that should not be committing tax fraud. And I think that happened here. There was lab equipment, lights, and security systems that were purchased for the grow operation, and it was inappropriately reported that the lab equipment and lights and such were a part of a sound and light business that the applicant operates. And I think we need to, take a hard look at that. That if you're willing to commit these other laws, whether it's violating the 2008 and you're making money, which he's doing off of a business as a caregiver, and then also with your federal taxes, claiming depreciation for items that you can't claim a depreciation for, I don't have any faith that they're going to follow our laws under the MFLA.
Any other comments? No. None? Okay, motion is to approve. Go ahead and call the roll.
Chairman Johnson,
No.
Donald Bailey,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 3 yeses, 2 noes. Motion passes.
Thank you. Number 13, 2540 RP LLC. Any member wish to make a motion here?
Mr. Chairman, I move that 2540 RP LLC has pre-qualification status for a pending application.
Is there support?
Support.
Any discussion? Huh? Go ahead and call the roll on 2540 approval.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Thank you. Number 14, Michigan Harvest Company. Thoughts and wishes of the board?
Mr. Chairman, I move that we pre-qualify Michigan Harvest Company LLC as pre-qualification status for a pending application.
Is there support?
Support.
It's been moved and supported to pre-qualify Michigan Harvest Company. Members, any discussion? Hearing none, go ahead and call the roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Thank you. Number 15, Green Bronco LLC. Thoughts and wishes for Green Bronco, anyone? I will move to pre-qualify Green Bronco LLC.
Support.
Is there discussion? Hearing none, go ahead and call roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Thank you. Number 16, exclusive brands for pre-qualification. Thoughts by anyone? Wishes, concerns, motions?
Chair, move that Exclusive Brands has pre-qualification status for pending application.
Is there support? It's been moved and supported to pre-qualify Exclusive Brands. Is there discussion? Discussion? Go ahead and call the roll on Exclusive Brands to be pre-qualified.
Chairman Johnson,
Yes.
Donald Bailey,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Okay. Number 17, 4D Mar LLC for pre-qualification. Members with any questions, motions?
Mr. Chairman, I move that 4D MAR LLC has pre-qualification status for a pending application.
Support.
It's been moved and supported to pre-qualify 4D Mar. Any board members wish to comment? Hearing none, go ahead and call the roll.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, motion passes.
Okay, number 18. Chris, is that the one you,
Yes, these are the same people involved as in Free Reign and 2540 RP.
any wishes here?
Chairman, I move that Sensoria has pre-qualification status for pending approval.
Support.
It's been moved and supported to support Sensoria LLC for a pre-qualification. Any discussion by board members? Hearing none, go ahead and call the roll, please.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses, motion passes.
Okay, the last one, number 19, the Source Direct.
These are the same individuals as in professional growth.
I move
Ventures.
to deny the Source Direct LLC's application because the applicant is not qualified to receive a license under the Medical Marijuana Facility Licensing Act, Section 402, Number 3, Letter A.
Support.
It's been moved and supported to deny the Source Direct application for pre-qualification. Is there discussion by the board members? Go ahead and call roll, please. Remember, it's to deny, so yes vote would be to deny.
Chairman Johnson,
Yes.
Donald Bailey,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
David LaMontagne.
Yes.
Chairman Johnson, you have 5 yeses, motion passes.
Thank you. Okay, we're down to department reports. Mr. Director, you have the floor.
Thank you, Mr. Chairman. Wanted to provide the board with some updates and some information about the happenings within the department since the last board meeting. In terms of application status, I wanted to give you some new figures, the volume of applications that we have on file now. Pre-qualification applications, we're up to 546 that have been filed and paid for. Grower operation applications for grower A's, we have 10, grower B 3, grower C 79. We have 28 processor applications, 81 provisioning centers, 6 secure transporters, and 5 safety compliance facilities. And at this point, by our best count, we have 96 municipalities that have adopted an ordinance to opt in under the MMFLA.
What was the total number again?
Of which one?
Total of everything?
Oh, I didn't add them up.
Didn't? Oh, okay. All right. I thought, guess that's why I didn't hear it.
That's why you didn't hear it.
Sorry, I just.
Wait, don't make me do math on the fly, please. Also wanted to let the board know, as I'm sure you're aware, we issued some advisory bulletins in the past month. We issued one on May 10th to clarify the definition of marijuana in Michigan. That definition is used in the Michigan Medical Marijuana Act, the Medical Marijuana Facilities Licensing Act, and stems from the definition in the Public Health Code. And that products derived from the cannabis sativa plant are not exempt simply because they have low or no THC levels. I think there was confusion in the public about that. And also clarifying that the exemption for industrial hemp under the Act only pertains to colleges or universities or the Department of Agriculture in conducting research programs that are authorized under MDART's program. I also appeared on the first episode of Laura Live, which is a Facebook streaming event, to talk about that bulletin and try and get that communication out there and answer some of the questions we'd received about that particular topic. We also posted in the past month inspection guides for each facility type as a reference point for applicants so they can see the criteria that our field inspectors will be looking at when they go visit those facilities, and citing all the rules that support the criteria that we're looking at. So when they're preparing their facilities, we can hope to expedite the process by notifying them in advance of the things that we'll be looking for. Any questions from the board about any of that? Also, the new emergency rules were signed by the governor and filed yesterday, 5:30. Did extend the deadline for temporarily operating facilities with local authorization from June 15th to September 15th. We want to make sure that everyone knows that those facilities temporarily operating should immediately file the step 2 of the application if they've not already done so. As the board has seen, everything we've presented thus far has been the step 1 application, and the quicker the applicants get that step 2, and the more likely it is that their full application can be considered, and that we can get fully operational facilities licensed. Even though the step 2 application is smaller, the investigation and inspection process is still time consuming and needs to be coordinated across multiple agencies, both within LARA and MSP and Bureau of Fire Services and local building inspectors as well. And a delay in filing that will impact our ability to present those to the board. So we're encouraging applicants, if they are temporarily operating, to submit that step 2 application. We also, in the emergency rules, added some clarification for testing standards based on guidance we'd previously issued through technical advisory. So essentially just codifying what we'd already clarified through those technical bulletins. Any questions from the board on that?
Director Griswold, and this may be more related to the very first topic you talked about, municipalities that have opted in. I know Detroit, they intend to be in, but I think they're out right now. I'm not really sure. Do we know where we're at with that?
Yeah, so in speaking with officials from the city of Detroit, they have what they would call a general licensing ordinance. They are working on amending the zoning ordinance. Their existing zoning ordinance, they're able to give authorization to provisioning centers, but no other license types under their existing zoning ordinance. So at this point, they have been able to sign attestations for facilities that are operating as provisioning centers, but no other types of facilities until that amended zoning ordinance goes through.
So I know we had there was some enforcement action just 3 or 4 days ago in the city of Detroit, and that is not a temporary operating because it was a grow operation that doesn't have a local authority to operate.
Correct. The temporary operation authorizations from the city of Detroit were only for provisioning centers, not for any other type of facility.
Okay, there seemed to be some confusion in looking at that particular case, but there's no temporary operation there. So thank you.
Correct. And just wanted to update you. I spoke, I think it was at the last meeting, about the vendor spotlight. We are still taking the lead in the executive branch on examining banking solutions and financial aspects for this industry. We have not scheduled that vendor spotlight yet, but we have been communicating with interested vendors who want to offer their insights into varying ways to present solutions for the banking challenges with this industry. So we do have a meeting scheduled soon with the Department of Insurance and Financial Services, the Department of Treasury, the Michigan Bankers Association, the Community Bankers of Michigan, and the Michigan Credit Union League, so we can explain our vetting process, our work with the board in terms of qualifying applicants, and our due diligence on the front end as we work toward issuing licenses, and get a sense from individuals representing the banking side, the banking industry, about what we might be able to put in place that would give them some level of comfort for banking businesses in the industry. Happy to take any questions about anything from the board.
That meeting is going to be soon then?
Yes, I think it's in June. Get the date, yeah.
Good.
Any update on anything from a federal perspective?
Lots of rumors and speculation, but nothing official.
Keep hope alive.
Director, we have these periodically, and maybe even more frequently than that, we have these marijuana events that are clearly outside the medical marijuana realm that take place. I know the High Times Cannabis Cup is coming in next weekend, not this weekend, but next weekend. They're going to be in town. We had some kind of a THC expo in Detroit in March, where Detroit PD, I believe it was, took some enforcement action, and there were a number of folks that it may be in the application process. And I know from my experience with the state police that this the High Times Cannabis Cup has attracted 300-400 vendors to sell marijuana products up in Clio. I don't believe they are, we haven't seen anyway, that they're an applicant. And all these facilities are processors and growers are going up there to sell product. Are we able to do anything about that?
Well, our purview relates to licensed facilities and the applicants. And so we continue to conduct those background investigations. So if any information were to become apparent related to activities of any applicant, that information will be presented to the board. So if they're operating outside the bounds of the law, if they're charged with any crimes, we'll have that information and we can present that to the board.
So if law enforcement was attending those events and said, XYZ is up here selling marijuana product in a recreational environment, that information would get to us eventually when an application, if they had an application pending, that information would get to us eventually.
Very well could, yes.
Thank you.
Anything else for the director? Thank you, sir. Okay, public comment. Paul Samways. Yeah. Oh.
Thank you very much. Good morning, Mr. Chairman, members of the licensing board. I appreciate your valuable time. What I want to talk about again is the fact you guys aren't getting all your information, okay? You're not getting predecessor companies' tax returns. What's happening is a lot of these applicants are changing the new LLCs to switch and move to keep you away from seeing what they've been doing for the last 7-8 years. On May 3rd, you approved a dispensary grow processor in Ann Arbor that I know does.
We need to avoid discussing pending applications, including those that have not yet made it to full licensure, the full licensure stage during public comment. The board needs to consider information that comes to them through the investigation process rather than through public comment. So if we could avoid speaking about specific applications.
Okay, no
we'll
problem.
do that.
Yeah, absolutely. But you're not finding out what's been going on for 7-8 years, making millions of dollars in a lot of places like Flint and Detroit that needs every dime they can get. These folks are making millions of dollars and not paying their fair share. Okay, it's not a victimless crime. This money pays for a lot of cops and it pays for the bulbs for the streetlights. Okay, so I don't see a lot of nuns' habits or priest collars up here. You're not seeing the Little Sisters of Mercy. This is about money. And unfortunately, Laura's 14 processors, none of them have any accounting background or accounting experience to understand what they're getting, which has resulted in a lot of letters of deficiency to my clients. So you are the board. You ride the horse doesn't ride you. So if you guys want this information, you need to find out if this operation was open prior, if it was registered as a for-profit instead of a nonprofit, because there are no nonprofits in the United States other than one that's been approved by the IRS that's a religious organization. Okay, everybody was making money. That's what this is about. We need to look closer at the money because the last time I checked, and I'm not an attorney, but as a CPA, I know tax evasion is a crime too. Thanks.
Okay, Lance Bouldry.
Thank you. I want to speak briefly to the advisory bulletin that Director Brisboe referenced at the beginning of his comments that said a little bit more than just that low THC and hemp-derived products are marijuana under Michigan's definitional structure. It also concluded that any CBD-derived products also fit within that definition, reaching the scientific conclusion that any CBD derived from the mature stalks was actually on those stalks because it came from the non-exempt parts of the plant. I appreciate very much Laura's willingness to continue to engage in conversations around that issue because the science simply doesn't bear out the conclusions that were reached there. The scientific study was a 1971 study of the research plants in the University of Mississippi. There are contemporaneous studies that reach different conclusions. Plant breeding is far different today. And so the science simply doesn't hold true. So I hope when the board is presented with applicants who've been involved in the sale or manufacture of CBD products, that they will look to see that in the case of applicants who did their legal due diligence ahead of time, understood that CBD isolate derived solely from the mature stalk was in fact exempt, and continue to do their due diligence as to the source of that CBD isolate for their products, that the board will not consider those applicants to have been engaged in the sale of marijuana because they were not. Thank you.
Mr. Hoffman.
Hey, good afternoon. My name is Matt Hoffman, and I want to talk to you about employees. I know that we're approaching the part 2 of the application, so now it's time to start talking about that. The reason I want to talk to you about that because it's the most important part of this whole process is getting the people that have the skills and capabilities to work within the industry and make sure that it's successful. So my first question is how does a potential employee with a record enter the review process, and will letters of support and intent from a potential employer aid their case? Next thing is how often will the determination meetings be held, and how long is the review process for that employee? When we look at people that have the skills and the experience to work in the industry, it would be unfortunate to have them held up in a holding pattern for months on end, making a determination whether they're eligible to work in the industry or not. Okay, once an employee is approved to work in the industry, is that approval specific to that facility, or is it the industry as a whole, sort of like a passport? Thank you for your time.
Robert Hendricks.
Good morning, Mr. Chairman, members of the board, and members of the Bureau. I'm Bob Hendricks from the law firm of Wrigley, Hoffman, Hendricks in Grand Rapids. And although it may seem a little premature to begin discussing the renewal of licenses that we haven't even issued yet, we were looking at the statute, and under Section 4029 of the Facilities Licensing Act, licenses are good for 1 year. We know that the the Bureau has established the state's fiscal year as the year for determining and establishing the regulatory assessment. It may well be that the fiscal year is also the year of the application life. So if we issue licenses in the next couple of months, those licenses will come up for renewal in October of this year. The board has to approve a renewal, and the last board meeting before October of this year is on September 13th. So what the industry and those of us who are providing assistance to folks who are trying to work through this process, what we need is sooner rather than later some guidance on what that renewal process will look like and how we're going to get before the board to do this. Again, I know it seems a little premature to be talking about that when not a single license has yet been issued, but we may be facing that sooner rather than later. Thank you very much.
Thank you. Adam Duke.
Thank you. Good morning, Mr. Chairman, the board, and Laura. I'd like to commend you on doing a good job. I think that this has been a very transparent process, and since the cultivation work group last fall, there's been a lot of good information that's come out. Thank you to Director Brisboe for touching on banking and compliance. I work with existing shops that are far from being compliant now, and one of the big issues in the public safety issue around the transport of money. Cannabis and bank, we all know that cannabis and banking are big challenges, but it's critical to the success of our industry. The companies use the bank, and we don't repeat the issues that just happened in Illinois, where a bank opened up their doors to cannabis businesses, didn't do their compliance, didn't do their Bank Secrecy Act, anti-money laundering, FinCEN compliance, and every one of those companies 2 years later ended up getting a check back. That just happened in May. There are 400 banks around the country that are currently banking the cannabis industry, and I'm not currently aware that there are any that are exclusively in Michigan. Proper compliance requires suspicious activity reports, know your customer forms, and businesses should stay away from banks and financial institutions that don't ask those questions and don't fully comply. Luckily, been talking to Director Brisboe. I am working with a financial institution that's operating around the country. They have vaults here in Michigan where they can provide a cash transport service to pick up cash on a nightly basis, reconcile it, and provide full compliant 2014 FinCEN guideline requirement banking for the cannabis industry. So looking forward to that meeting in June and to that vendor spotlight that will be coming up. Thank you.
Thank you. Dan Munzu? Right, Dan?
Good morning. Thanks to the board and the agency for all your hard work here every month. I'm with a company called Twister Trimmers, and we manufacture automated harvesting equipment. So for me and my job and my success, it would be very helpful to get information on the approved applicants through FOIA, the Freedom of Information Act. So if there's any way that Laura or any of the agencies could go ahead and publish some of the contact information, so I could reach out and other businesses in the state could reach out to some of these larger farms and provisioning centers. That'd be real helpful. Thank you.
Thank you. Christina Montague? Am I saying it right? Thank you.
Hi, I'm from Ann Arbor, and so I know what you're talking about. I just want to thank this board because you really did educate us well. And I think that you have done a good job. People might not say that. But one thing that you need is a way for people like me who became a victim, who got sued, had to spend tens of thousands of dollars just to defend myself and say I belong there on my spot. The city of Ann Arbor, the city attorney, deputy city attorney went to court with me and just told them these guys are just trying to take her place because they got a lot of money. So I've, the Ann Arbor police have been very responsive, but the state needs a way that we can report these bad players who are going around just to try to stick people up. That's all I got to say.
Thank you. Eric Foster.
Thank you, Mr. Chairman, board, and staff. Just my question, at earlier board meetings, when looking at the pre-qualification applicants, you used to list what classification area they were in, be it if it was secure transport or if it was a provisioning center or the like. And I was hoping that you all would get back to that to just try to at least have some sort of understanding of, with the applicants like the 19 today, which of the classifications did they fall under? I'm with a consulting firm, Cannabis Practice Group, that works with companies in the industry, but just from a processing of where we are in the process, it is helpful. It was helpful when you were doing it beforehand, and I would hope that you would start back doing it again. Thank you.
Thank you. That is all the cards we have. Our next meeting will be June 11th, 9:30 at the Williams Building in the auditorium there. I like, because we have more room up here. Any other comments from the board?
Yeah, Mr. Chairman. Oh, go ahead.
I actually have a question for Laura. Is there a way for people to call in anonymously if they are aware of organizations that are doing things that may not be ethical?
Yes. We have on the website, we have a phone number posted for our enforcement section, so people can make complaints and they can submit them anonymously.
Therefore, individuals here today who have indicated such, there is a means for them to do it.
Yes.
Okay, great. I just wanted everybody to be aware.
And to follow up on that, Vivian and I were apparently channeling. The Michigan State Police also has a tip line. If it's a licensing issue, then it's a LARA issue. If it's a criminal issue, which so much of this there's overlap. If it's a criminal issue, that would be the state police. And 800 Mich tip, is that? I don't see anybody from the state police. Yeah, you call any Michigan State Police post, they will take that information, or they will give you the tip line, and probably the Michigan.gov website would have that tip line. But if it's a criminal issue, they will take that information and they will deal with it. I know they've gotten a lot of information already, and they'll continue to. My guess is that Laura probably has gotten a lot of information on bad actors as well. The issues that we have across the state, because we're in this process of getting people licensed, is there's a lot of stuff going on that's not correct. There's a lot of product being sold. There's a lot of product that's not tested, that's in these temporary operating dispensaries. That's a problem. It needs to be tested. We need to be paying attention to limits that people are purchasing. There was just another big case where 20 pounds of marijuana was leaving a dispensary in Michigan in the past 2 days, going to Wisconsin, 20 pounds. Marijuana from Michigan going out of state. That's a problem. It's going to continue to be a problem. And we need that information. So when people know that, they can call the state police. That would be great.
I think that's.
Is it Mich tip?
No, it's the 517 number right there.
The phone number for the state police is 517-284-3388. And that's the state police marijuana, thank you, Brian, and tobacco enforcement. That'd be helpful for all of us going forward, and particularly for those that are getting licenses. It's going to be really helpful for you. We need to know who the bad actors are and who the good actors are.
Well, again, thanks for the public coming. Appreciate all the board members. Thoughts and comments?
Motion to adjourn.
Is there support?
Second.
Motion is to adjourn. All in favor, say aye.
Aye.
Opposed, no. We are adjourned.
Yeah, that was actually fun.
You